Are employment contracts required for Canadian workers? Why written contracts matter even when not mandatory? In most Canadian jurisdictions, there is no rule that says every employee must have a long, lawyer-drafted written contract. An employment relationship can exist based on verbal agreements and conduct alone. But just because written contracts are not strictly mandatory does not mean they are optional in practice. For a foreign employer, especially a US company expanding into Canada, written agreements are one of the main tools you have to bring clarity and predictability into an unfamiliar legal environment. Employment relationships without written contracts. When there is no written contract, the law fills in the gaps. Statutes set minimum standards for wages, hours, overtime, vacation, and termination. Courts supply default rules about notice periods, benefits, and other terms based on past cases. In that world, you lose much of your ability to shape the relationship. If a dispute arises, the question becomes what a court thinks is reasonable, not what you thought you were agreeing to when you made an offer. What written contracts can actually do. A well-drafted Canadian employment contract does not let you escape minimum standards, but it allows you to define key terms within that framework. You can specify job duties, compensation structure, eligibility for bonuses, probation periods, intellectual property ownership, confidentiality obligations, and how much notice or pay is owed if employment ends without cause. If those terms are drafted clearly and in compliance with employment standards and human rights rules, courts will usually enforce them. Termination clauses and predictability. Termination is where written contracts earn their keep. Without a valid termination clause, employees dismissed without cause can claim reasonable notice under judge-made rules, which can be significantly longer than statutory minimums. A contract that sets a clear, lawful formula for notice or pay in lieu gives both sides more certainty. For foreign employers used to at-will concepts, this is a critical adjustment. You do not need to fear Canadian termination costs if you understand them and build them into your contracts from day one. Probation, duties, and role clarity. Written contracts also help with the basics. Probationary periods, for instance, need to be spelled out if you want them to mean anything in practice. The same goes for job duties and reporting lines. When roles are vague, performance management becomes harder and disputes about expectations become more common. A clear contract gives you a reference point when you need to adjust duties, manage performance, or defend decisions later. Protecting confidential information and IP. For many cross-border employers, protecting confidential information and intellectual property is a priority. Written employment contracts are where you clearly state that work product belongs to the employer, that confidential information cannot be used or disclosed outside the job, and that employees must return company property when they leave. Without those express terms, you may still have some protection in law, but enforcing it becomes more complicated and uncertain. Limitations on restrictive covenants. Some employers also want to use non-competition or non-solicitation clauses. In Canada, especially for non-senior roles, non-competition clauses are often difficult to enforce, while narrower non-solicitation clauses stand a better chance. Written contracts are where these restrictions live, but they have to be drafted carefully, tailored to the role, and consistent with evolving legal standards. Copying aggressive US-style clauses into Canadian contracts is a recipe for disappointment. Fixed term versus indefinite term arrangements. Contracts can be written as fixed term with a clear end date or as indefinite. Fixed term agreements sound appealing when you want to test the waters in a new market, but they have traps of their own. If you end a fixed term contract early without a proper clause explaining how termination works, you may end up owing the balance of the term. Indefinite term contracts with clear lawful termination clauses often provide more flexibility and fewer surprises than a series of short fixed terms handled casually. Offer letters, handbooks, and formal agreements. Not every situation requires a long, dense contract. For junior roles, an offer letter that includes essential terms and incorporates a short set of standard conditions can be enough as long as those conditions are drafted with Canadian law in mind. Handbooks and policies can sit alongside contracts, but they usually do not replace them. You want a clear, signed document that sets out the core bargain, role, pay, location, hours, termination, and key obligations. Updating contracts as your presence grows. Contracts are not static. As your Canadian operations grow, you may refine your standard templates to reflect lessons learned, new benefit structures, or updated legal advice. It is normal for later hires to have slightly different contracts than early ones. The important thing is to ensure that each version is coherent and compliant on its own terms. Periodic reviews of your contract templates, especially after legal changes or business shifts, keep you from relying on outdated documents that no longer fit how you actually operate. Language, accessibility, and employee understanding. A contract that no one reads or understands is not very useful. Using plain language that reflects Canadian concepts rather than US jargon makes it more likely that both sides are genuinely on the same page. For employees whose first language is not English, it may make sense to provide translations or at least walk through key points verbally. The goal is to produce a document that will stand up in court and also make sense in everyday use. Final thoughts. Employment contracts for Canadian workers are not always legally required in the narrow sense, but they are practically essential for foreign employers who want predictability and control. Without them, default rules step in, and those rules may not be the ones you would have chosen. With well-drafted contracts anchored in Canadian law, you can define clear roles, manage termination risk, protect intellectual property, and set expectations on both sides. In a cross-border setting, written contracts are less about formality and more about making sure everyone actually understands the deal. If you require assistance with Canadian tax matters, our team is ready to provide reliable professional support. Please contact us at 416-283-8774 or visit theaccountingandtax.com for more information. And if you found this video helpful, don't forget to like, subscribe, and share.